All right. Okay, let's get started. Shen, if you don't mind unmuting, and then also Michael too. Perfect. Welcome to our CAREA WebEx speaker event on estate planning for real estate professionals and investors. I'm Michelle Chen, a commercial real estate broker with Fiduciaries Commercial, and part of this year's board for CAREA, and I'm honored to be co-hosting today's event with CAREA Vice President Shen Li with Intero Commercial.
Okay. Thank you, Michelle, and welcome everyone for joining us. We have a great topic today on estate planning for real estate professionals and investors for a very short 1-hour speaker event. We know it isn't easy to focus on anything other than what's currently happening out there in the world and in our own communities. So I want to take this time to thank you for being here with mindset of education, learning, and self-growth together. To briefly introduce us, the Chinese American Real Estate Association is a nonprofit organization established to promote the social and economic well-being of our associates, and further the professional image of Chinese American who are engaged in the field of real estate. We warmly welcome you to join and become one of our members. For details, please email us at careaofficial@gmail.com. This event is being recorded for some of our members who cannot make it today, and can be found on our YouTube channel or on CAREA website. We will also be emailing everyone the recording and slides the next day. So let's get started by welcome Michael Li, the managing partner of a premier Bay Area law firm specializing in estate and tax planning. Michael represents multinational companies, company directs, officers, persons of multiple nationality, tax obligations, and fiduciaries. Okay, let's welcome Michael.
Thank you all for welcoming me, and I greatly appreciate being here, and I really appreciate your introduction and points that you made, Shen. Thank you all attendees for joining. The world is going through some difficult times now, and I really appreciate us working to act and do things during this adverse time and keep momentum and keep positive and try to learn and expand and grow. And I think this is great. And I love seeing everyone here, and I hope to have a good time here. I've worked with the Chinese American Real Estate Association for a good long time now. And can you believe I actually am a Chinese American person? My father's Chinese, my mother's Irish. So we have a lot of fun. This format, as Michelle introduced, is a great format because you can also ask questions. So do take advantage of that. So actually, I think in some ways, this is better than in person because you can drop your questions in. And as I'm doing the lecture, I can answer questions or guide what my topic is to reflect what you want to hear. So this is very interactive and very fun. The only thing I will miss is usually I got a good lunch when we would do it in person. So I guess we'll have to do takeout this time. But let's get on to our topic. So what we're doing for our topic today is a little bit of a more advanced talk from where we were before. I've done the sort of classic estate planning lecture before. And I think most of you already know all there is to know about that. So we're going to go beyond the basics. So what do we have here? What do you already know? I think you already know estate planning in the sense that smart families do planning. Smart families, and especially California families, don't leave things to chance. They don't say, the will that California would give me based on the thinking of the way families work in 1850, I'll just take that and I'll just let the court sort it out. I think anybody who's a participant and a member of CAREA doesn't want to do that and already knows. So we already know, okay, we're going to do some estate planning. And you'll see, you already know how to do it, I think. I think you've already heard that you say, okay, I need a revocable living trust, and I need a will, and I need maybe a durable power of attorney and a healthcare directive. And I'll hopefully go see a lawyer, and he or she is going to put a lot of text on the page, and that's going to do what I want. But that's actually what I want to talk about today, of what do you want to see in your estate plan? What should be in there? What are the questions you should be asking? And what are things that you can do in your plan that can achieve your objectives? So, what do we want the plan to do? This estate plan, should actually be a roadmap for what we want to have happen to our assets and even to our children or to other members of our family, how we want this to work. So let's start putting in some directions in our map and figuring out what we want it to do. So I have a little roadmap to start. We're going to talk about 6 things, but as anybody who's a lawyer, we're going to wind around a little bit and try to make sure that we answer your questions and give you some good information. So we're going to start sort of in 6 areas that I think are pretty common to go beyond just, okay, the trust avoids the probate, the will is a backup. Okay, we already know that. Let's take a look at how these things actually work. So we're going to go through our considerations. So let's take a look at the first one. The first one is obvious. So consideration 1 for a good will, trust, estate plan, we want to avoid probate and efficiently administer assets. Okay, so what's the first thing that you do? Establish the plan. Great, perfect. We already established, we already know that. But here's the second thing, funding the plan. I get cases on this every single year of people have a beautiful trust. It's in a beautiful binder. It's on great paper. It looks fantastic. And they say something terrible has happened. We need to begin to administer the trust. Oftentimes, I get this referral from you guys because you go to sell the house and it says, Bill Chen, an unmarried man. Or you say, that's a problem. The family says Bill Chen has passed away, and here's the trust. And there's the problem. The property is over here, and the beautiful trust is over here. And nobody bothered to put this together. So the trust, beautiful, probably paid a lot of money for it, will not do anything for that property. You actually have to get the property into the box. So thinking of doing your trust, it's not just seeing the lawyer and making sure that it gets all signed. You have to make sure all of your real property is titled in the name of the trust. So you're going to have to work with your attorney or title company or deed company, make sure all the real properties are deeded from, let's say, Michael Lee, a married man, to the Lee and Lee family, revocable trust 2020. We have to do that. The second thing that we have to do is think about financial assets. I'm talking about bank accounts, brokerage accounts, not retirement accounts. We'll talk about that in a moment, but bank accounts and brokerage accounts. There is a special rule in California that if the aggregate amount of financial assets, and all other assets, by the way, is less than $166,000, you don't need probate. You can just use an affidavit. So what good planning is that we make sure that all the real estate is in the trust, and we have to take a look for large bank and brokerage accounts. Classic mistake too. We have all of the real estate in there. We have all of that set up. We have the beautiful trust. And then we find out that nobody titled the Charles Schwab account into the trust. And the Charles Schwab account has $1 million in it. And we say, well, can't we just get that into the trust? Well, maybe, but not that easily. We're going to have to go to court. Maybe we can avoid probate, but we're going to have to go to court. We have to make sure that not just the real estate is in the trust, we got to get the financial assets into the trust. And any bank, brokerage account, company, they'll know how to do this, and your attorney can guide you. But don't forget those things, because that's one of the classic examples of, we have the great trust, we have our box, perfectly constructed, but we forgot to put something in there. The third thing that a lot of people forget to do is, and this is again common for real estate professionals and small business owners, is that if you own a business, you have to get that into the trust. So if you have a closely held corporation, you need to assign your stock into the trust. If you had an LLC, you have to assign your membership interest into the trust. But be a little careful with your LLC. If you are in an LLC with other people, that are not related to you, you have to look at your operating agreement and see if that's okay. If not, if they say, oh, the other members have to consent, you just have to send out a little letter to everybody to get them to sign off and make sure everybody consents. So there's a process to completing the trust. After you've completed the trust by signing, you have to get everything in there. So the last thing, or the next thing, fourth thing that I want to mention is a new thing you probably have heard. It's a little bit complicated, so we're not going to spend too much time on it, but something to also think about is pension and retirement accounts. The Secure Act, it's a new congressional act. One thing that Congress did do last year was that there is a new law about how pension accounts and retirement accounts are taxed if they do not go to the beneficiary directly. So the only thing you need to know about this is two things. One is generally, if your beneficiaries are over 18 and they are responsible and appropriate to be named for the retirement account, name them as the beneficiary directly. It will avoid a lot of tax hassle. The old way, where you would just name it in the trust, that can be a little bit of a problem under the Secure Act. So you have to be a little cautious about that. You can still do that. Let's say my family, I have a 1-month-old and a two and a half year old. They really can't receive a retirement plan right now. I need something like a trust to hold it for them. You can do that, but you want to make sure there is the new Secure Act language in the trust to make sure you don't have a pretty ugly income tax problem. Basically, the thing is that if the retirement plan, a 401k, goes into a trust, and it is not a trust that has a special provision called conduit, it's deemed income taxable right then. So all of that back income tax you have to pay, and it's really not a good thing. So the key thing is take a look at it if you have large pension plans and get some advice. The last thing that I want to talk about for this consideration one is LLCs. Be careful with LLCs. LLCs, I love LLCs, but I also have some not so great love for LLCs. They have to be used wisely. And what's the reason why they have to be used wisely? Because the LLC is another legal person. So if the classic joke, there was a guy in Marin County that objected to the carpool lane, objected to the carpool rules, and he also objected to corporate personhood. So he got his corporate binder and he put it in the passenger seat and was driving up and down the 101 trying to get a ticket because he said, oh, I have a second person in here. I have me and I have my corporation. It's a legal person. The court wasn't laughing, but it's a good principle for this with LLCs. You have to be careful. Lawyers, accountants, if they just automatically say, oh, you have rental property, throw it in the LLC. Ask, okay, explain why. And you should listen to the two things I have on this slide. One where the LLC not so good. Property, single family residence or a condo. You use ordinary homeowners insurance as second property. There are no multiple owners. And it's maybe your first house, or it's a house somehow you inherited maybe from your parents. It has a very low tax base, and it's super low risk. It's a condo. It has the HOA insurance, plus you insure, plus when you have the renter, you make them insure. This is a super low risk property, super easy to deal with, not problematic. And key, if it has a loan on it, you have to be careful. Putting this into an LLC is going to cause a problem. Why? Your ordinary sort of second home homeowners insurance, no good. They're going to want you to get a commercial policy because they're going to say, oh, you don't own it anymore. It's not in the name of Michael Lee. It's Michael Lee LLC. So we're going to not necessarily give you the same insurance rating because it's now a different entity structure. So be very careful. The worst thing you can do is you transfer the title. You don't update the insurance. Something happens and the insurance company says, whoa. We never insured Michael Lee LLC. We insured you and you don't own it. So that claim, not our problem. And anybody who's worked with insurance, the job of insurance is to deny the claims. So you have to be very, very cautious. Second thing is, it ruins your ability to give your kids the property tax basis because there are two benefits for Prop 13 and Prop 58. And one is my primary residence. That can descend to my children, keep my tax basis. And I have $1 million wild card. If I have another property, I can stick that $1 million on the other property and keep that tax basis low for my kids too. So I can get both. But the property has to go through, it has to be in my name or my revocable living trust. If I put it in an LLC and the LLC drops down to my kids, the California State Franchise Tax Board says they didn't inherit anything from their dad or their mom. They received an LLC interest, and that's not exempt under 58 or 13, and they will reassess the taxes. So it can be, so for something like a condo or a second house, like, whoa, that's not a good idea. What about one where it's a good idea? Think about this one. The property is a commercial property. It already has commercial insurance. Maybe you own it with other people. And the classic one, it has a triple net lease and it's a high risk property. I had someone where we had almost an emergency getting it into an LLC. It was a 9-bay auto repair shop. So like for auto, cars go in there, and it had 9 bays where the cars went in. Super dangerous property. Somebody could be injured at any moment. You have cars going in and out, cars up on lifts, super dangerous. And if you have a tenant, how do we solve all of the things we mentioned? There was a problem for the small property. Insurance, no problem. We already have commercial insurance. We make a call, they switch it. What about the property tax? What if they reassess the property tax? If I have a triple net lease, if I'm the owner, do I really care? No, I'm going to put that through with the CAMs. And that's going to just get pushed through to the tenant. So I don't really worry that maybe when I pass away, we're going to not be able to use the property tax basis because we don't pay it anyway. Also, it is a high risk property. The odds of, let's say, the auto repair shop, someone getting injured or killed, very, very high. I don't want that mess coming back into my estate. I want to contain that right there. Unlike a condo, what could really happen there? We have to judge the risk. Instead of paying the $800, for the LLC and all the legal work, just get a huge umbrella policy. Stick the $800 over on the huge umbrella policy, because nothing solves a lawsuit like a gigantic check from Allstate. That solves a lawsuit every day of the week. But something clever where you say, oh, it's behind an LLC and the LLC lent money to another person, so it's insolvent and all of this, that just gets more lawsuits. That makes people mad. Giant checks from Allstate makes people happy, and they go away and they stop bothering you. So those are some of the tricks for using LLCs wisely in your estate and not doing, I had a classic case where someone put a condo in there. They got the Northern California professional tenant, and the tenant was able to successfully fight the eviction, because when the woman brought the eviction, she brought it in her own name, and then the person said, you don't own the property anymore. It's the same way as if I went to try to evict it. They say, you have nothing to do with the property. So I had to file it again. Then the LLC, is hung up in it. Huge problem. So key thing, use LLCs wisely. Make sure the plan is well funded. So what about our consideration 2? Consideration 2 is actually, we're going to start taking a look at the trust itself. Trust can do very interesting and sophisticated things that is much more sophisticated than a will, and much more sophisticated, vastly more sophisticated than doing nothing. If you are married, you can create a trust, and this is very common, where, of course, you each have your community property, and you can design the trust depending on your preferences for, of course, your property and your feeling regarding your spouse. So you can decide, do we want a trust where if I go, my wife has high freedom over all of the trust property and she can do whatever she wants. She could sell everything and fly off to Mexico if she wants. Or do I want something that's a little bit more restricted, that if I pass, my side is somewhat locked and she has to have certain conditions or constraints to make sure that my share goes to my kids and not to someone else. So the thinking about marital trust, you can think sophisticated, have a sophisticated thought about this of, do I want something where you say, well, I want to grant my spouse high amounts of freedom, but if he or she remarries, I kind of want this to lock and I want that to go to the kids. I don't want my spouse to remarry and then maybe that person has kids and then we divide it all equally among all the kids. I don't want that to happen. Well, you can completely do that. So I see this a lot of times, looking at trust that people have already done, And then we say, well, what are your preferences in this situation? And they kind of describe something. And they say, well, I want it pretty open, but I do have a little bit of concern about remarriage or something. And I say, well, your original trust doesn't say anything like that. It just says it goes to the surviving spouse and they can do whatever they want. That's the most common one. And that may not be what you want. So you can tailor how the surviving spouse operates. The other thing with this slide, I also like to mention, if you are a single person, estate planning is even more important because the automatic ideas of, well, it just goes to the surviving spouse, it just goes down to the kids, doesn't necessarily work for a single person. Yours needs a little bit more sophistication, a little bit more thinking through of, well, if something happens to me, what if I'm incapacitated? Who do I want to be in charge of my assets while I'm still living, but I can't operate so well? And then if it's time for me to go, how do we divide these things? How does that work? Often a lot of planning needs to be done there because that situation is less automatic. I can generally expect what married couples want. I generally cannot predict what a single person wants. I generally can't think of, I bet you have someone important. It requires a lot more input from the client, and it is great planning to achieve your objectives. So going on to the third consideration. This is, again, we were talking about side to side in the trust. What about up and down? This is another one where I see a lot of people missing a chance to achieve what they want to achieve. And this also creates, which we'll talk about in a later slide, a potential property tax problem. So revocable living trusts can create sub-trusts for beneficiaries. The trust does not have to operate like a classic will, and really shouldn't. The objective of the trust, you can do something like this. So if I have 2 children or 3 children, I can design the trust. They say, if something happens to me, I don't want it to say, Susan, Bob, and Janice, a third, a third, a third. Upon my passing, they get everything. Maybe I don't want that. Maybe there's, substantial assets. Maybe I say, the ages and things like that. I want to make sure that they receive the money at appropriate times, or they don't, sort of have, when I go, I don't want them to have they won the lottery feeling. I want this to be a little bit delayed or apportioned over time. You can do that. I threw 4 classic examples up here to see. You can do it by ages, where you could say, at the time of my passing, 25%, and then at 30 a certain share, 35 a certain share. You can do it by time. You could say on my passing a certain percentage, and then 5 years after a percentage, 7 years after a percentage. You can do something where you split income and principal. You could say income for life, and that's mandatory, and then principal will be determined by an independent trustee. If they want to buy a house, okay, the trustee will say, okay, that sounds like a good one, we'll do that. They say, I want to find myself in, Prague for a few years and just sort of mill around and become an artist. Maybe the trustee's not going to pay for that. You can have ascertainable standards, and you can have an active independent trustee. Or the fourth one, not very common for revocable living trusts, but very common for dynasty-style trusts. You say, to my children or heirs, as determined by my independent trustee. Often it will be to my heirs, as determined by my independent trustee. You'll have an open class, and you'll also, with this, sometimes have what's called a distribution committee, where your heirs, your children, become members of the committee. And because they hold interests adverse to each other, they, as part of the committee with the independent trustee, decide how it gets distributed year over year. And the last one, you can do specific distributions, gold watch to John, or something like that. So your trust can really do exactly what you want. And you want to work with your lawyer to design something that you think will work for your family. One of my favorite ones is that we designed for an Indian family. It was very interesting. They were a fairly high net worth Indian family, and they had 4 daughters. And the mother came in and said, oh, I know exactly the problem in my estate. The daughters don't care anything about the hotels. They don't care anything about the money. I have a lot of jewelry, and they will fight viciously for it. So it was a classic example. We created a special provision that basically what the provision was, instead of doing a specific distribution or any of these things, we said, okay, on the passing of the mother, the trustee will marshal all of the jewelry. The jewelry will be brought to the law office. The girls will each throw the dice. Whoever has the highest number gets first pick, next highest number second pick, on and on and on. And you go in rounds and we pull out of the pool until the jewelry is gone. And then the sort of beauty of this plan was that the mother was afraid. She said, well, I don't want to specifically give the property to one person, because then if I do it wrong, they'll hate me. And then I have this feeling of, well, wait, does somebody want sentimentality? They want the particular elephant brooch, or do they want money? They want the diamond ring. Or with the die system, they can choose. And the mists of fate are how it got chosen. So you can do, the point of the story is you can do clever things with your trust. You don't have to just accept, don't accept that the lawyer says, oh, just divide it evenly and just let's sign this thing and be done. You can do something smart, and you should. That's why you're doing the plan. So next consideration, moving right along here. My mouse here. There we go. So next consideration, and this bookends right with what I mentioned before with dividing up the property amongst family members. Think about the Prop 13, Prop 58. This is very important for planning, and I see missed by lawyers constantly, is not understanding how this works. You have to be careful with real estate. You have to be careful with real property because of the property tax exemptions, and they only go up and down. And the key issue with this is, the key thing is that Generation 1 parents can descend the primary residence and other property up to $1 million of exemption down to children. But it does not work side to side. So a classic example is if a family wants to provide for children and someone else, a brother or sister or something like that, that person, the brother or sister, really shouldn't get real estate because it's going to stick them with a tax problem. It would be much better that the real estate goes down to the kids and the retirement plan or the life insurance or something like that, the brokerage account, goes to brother or sister than the real estate. Because if you flip it and you say, oh, I'll give the vacation house to brother and I'll give the $1 million to my son, what's going to happen is that vacation house is going to get reassessed. So actually, if you flipped it, it would be more tax efficient to give the $1 million to the brother and then the real estate to the son. You can keep the low tax basis. And this is very, very common for things like vacation homes. A lot of times people will say, oh, we inherited, the La Jolla beach, property, or we inherited, the Tahoe property or something like that. It's just a beach property. And the reason it's so attractive and you keep it partly is because the carrying cost is so low. It's, mom and dad's old tax basis from the 1960s. But if that gets reassessed, it doesn't look good anymore. Happens classically to rental property. The rental property, your sort of cash flow income rate is because the property tax is not so high. As soon as that changes, your cash flow on the property totally changes. So you have to be careful with this, in the up, down, or side to side. The other thing you have to be careful with is be careful with the way the trust is designed. If you have children and you say, oh, it's just, it's called a residual clause. The lawyer just sticks in there and says, all everything in the trust, the residual, we split it 50-50. Boom, done. Well, you have to take a look or have at least a little bit of a thought. Is there enough property? And this is not just real estate, cash, all these other things. Is there enough that we can prevent split titles where we don't have brother and sister on the two properties? Because what can be an issue, classic example is there's just one property. If brother and sister take the title and then one party says, okay, just, sister, just buy me out. That's fine. You just, get a loan on the property. We inherited it free and clear. You have a great job. Just get a loan and just buy me out. That's going to cause it to be reassessed. And then this great, inheritance that sister got, she's going to be, oh no, not only do I have to pay brother out, I am now stuck forever with the reassessment. Because again, that's forever. Unless the property basis, we have an economic crisis like 2008, 2009, and you go through the board reassessment procedure, you get stuck with it forever. So don't lose good tax bases, because you're not just losing it year one, you're losing it forever, and you've completely changed the economics of the rentability of the property because the carrying cost is now higher. So make sure when strategically planning in the plan, where one may even guide, is say, okay, we have to give the Tahoe house to sister and the main house to brother because we don't want the tax problem. Or you can do this really cleverly. If you already know that daughter wants to buy the house or may want to buy the house, grant her an option in the trust. The Assessment Appeals Board of California says if you grant a child an option, that preserves the assessment. So if you say sister shall, the house shall be split evenly, but daughter will have an option to buy. If you put that option to buy, she gets to keep the tax basis, because they say what she received was the house with the option to buy. That kept, that prevented the title from being 100% brother, because she had the option to take it away from him if she could get a loan. So you could do something a little bit clever to keep the tax basis, and not just clever, something that well, actually, it was the Board of Equalization. The Board of Equalization says, yeah, we told you, we came up with that. That was the smart thing that we told you to do. People don't do it. Well, why they don't do it, nobody knows. But the Board of Equalization tells you exactly how to make sure that you keep the assessment low. So that's consideration 4. Moving right along, here's another thing. These are big topics, but I wanted to throw them in and to give us a little bit of a taste, just so you know that they exist. Again, you probably, if you're in CAREA, you probably already know these exist, but to do a little bit of a refresh. Put special assets, unusual things, where they belong in special vehicles. Classic one. Do remember this, and this gets a little bit, this is sort of the game of telephone that happens, is people hear things, and then as it goes down the telephone chain, the story gets a little bit mixed up. Life insurance. Life insurance, when it pays out, pays the death benefit, is not subject to income tax. The insurance broker agent was right. But sometimes they'll say it's not subject to any tax, no tax at all. Not 100% true. The life insurance in my name, if I own it in my name and I'm the insured, it is potentially subject to the estate tax. How can this be a problem? Well, if I have the Palo Alto property that's $2 million, $2.5 million, and I have my 401k that's let's say $2 million, 2.5 plus 2, and I, God willing, pass after 2025, my exemption is only $5 million after that date. I've used up all of my exemptions. What if I have a life insurance policy, a whole life insurance policy that's $1 million or $2 million? I thought that the agent broker said no tax. Yeah, no income tax. But that $2 million is added to my gross estate, 2.5 Palo Alto, 2 million retirement, 2 million insurance. I'm at 7. I have a problem now, because they're going to subtract 5, and we're going to have 2 over, and then they're going to hit it with a 40% rate. It's going to destroy the entire planning of the life insurance, because I just lost 40% of the life insurance. All of my clever planning with whole life insurance didn't work. So what do you have to do? You have to get it out of the gross estate. When you acquire it, when you decide, okay, I'm ready for whole life insurance, it's time, buy it through an irrevocable life insurance trust. Put that on an island. Get that out of the gross estate. And there's a sophisticated way that we developed in California twice, with the 2 cases were Crummy and the case of Cristobal, where we can basically create this sort of island trust. It's called an islet, but I joke it's like an island. And you can put money into the trust. You can avoid gift tax. There's a sophisticated way to do that. The trust buys the insurance on your life. The trust is the owner, not you. What you're gifting, that's subject to the annual gift tax exclusion, no problem there. And the policy is inside the life insurance trust. Especially good for real estate professionals, or I have the classic people who really like this, oral surgeons and dentists that get sued all the time. It's also immune from your creditors because it's separated from you, and you're actually having arm's length transactions every time you fund it. So no one can take that policy away from you. Guess how much you can keep of your whole life policy if you own it? About $14,000. That's the California exemption, $14,000. So if you get sued and someone starts collecting on the judgment, they can take the whole life policy. They can basically say it has to be surrendered. You keep $14,000. We take the rest. Bad result. So you can do the life insurance trust, and it's sort of a win-win-win all over. So that is the life insurance trust. The second one is, this one's great for real estate professionals. This one, keep in your back pocket for whenever you have somebody that says, man, I'd love to sell that property. That property, it's it's a very valuable property. It's been a hassle. I don't want to rent it. I would just love to sell it. But I, either I inherited it or I was granted it many, many years ago, from my parents or grandparents. It has a tax basis of $100,000. It's worth $1 million now. I would have capital gains of $900,000. And I don't live in there. I never lived in there. So I am totally exposed to the capital gains. Love to sell it, want to get rid of it, but I can't. Classic example, this is best told through a story. I had, and you may see something like this in your practices. It's very common. Young married couple, Chinese couple. The young man gets married. Grandparents, because they love the grandson, give him basically a San Francisco fourplex. Beautiful San Francisco fourplex. That's the wedding gift. Please, before you make big gifts for a wedding, go see a lawyer before you do this. Huge mistake. Give him the fourplex. He takes the fourplex. Okay, he's exempt from the property tax reassessment. They dodged that bullet. But now he has a fourplex. And anyone who knows San Francisco real estate, it's built before 1978. And actually, it has kind of a mother-in-law unit, so it's really more like 5 units. What's the problem with that? Rent control. It is rent control all over it. Pre-1978, over 4 units. Over 4 units, you may be actually considered in the business of renting. It basically just has all kinds of problems. So he has this beautiful property, but really at great risk of getting a bad tenant. And he's an engineer. The wife is also an engineer. They just don't want to deal with this thing. So what do? They just leave it. Beautiful property, locks on the doors, dark at night. They say, I'll just hang on to it. I can't do anything with it. Perfect example. And again, you think husband and wife, both engineers, they are at the top in their mid-30s, the top earning rate of their entire life. You have 900,000 or 1.5 million of capital gains. That is the highest rate you will ever pay in your entire life. So how do you get rid of this? How do you, but they, the thing is, all of us maybe in our 30s or 40s with children say, yeah, I'm in the highest earning bracket of my life. I don't feel like that. I have kids. I feel like I'm earning the lowest. I actually need income. How do you solve this? Charitable remainder trust. You can use this. And it was what we used for this family, is that basically you create the charitable remainder trust. You grant the property into the charitable remainder trust. The trust sells the property. These trusts do not pay capital gains tax. They're specifically exempt under the tax code. They don't pay it. Why? Because what they do is they sell it, they convert it to cash assets, they invest the cash assets. Inside the CRT, an annuity is created, and this annuity pays, of course, the value back to the family over time. You can design the annuity to backload it or front load it. So let's say now they're high earnings, backload the money so that as their earnings go down or they retire, the money starts to come as almost like a supplemental retirement plan. So you've flipped it. You've also gotten rid of the property at the right time. So for example, again, real estate professionals, that couple says, it was a couple of years ago, market was super hot. They say, I really got to offload this thing. Now they're, I'm sure they're thinking, thank God we did a fourplex right now with coronavirus. We'd be stuck with this and nobody's going to rent it. Good thing we offloaded this thing and now we get cash. You do all of that. And then the key thing though about ages is you replace the asset with a life insurance policy that is in your irrevocable life insurance trust outside of your estate. And the further beauty of this is because you've designed the annuity to make sure that 10% goes to charity at least. You basically take the value of the asset, You take out basically the value of the annuity, and you get a year one charitable tax deduction for what you put in. So high income earners get a huge tax deduction, which you could carry forward 3 years if you need to. So if it shields more income than you have, you just carry it over year. So you lower your taxes now, put the income on the back, get rid of the troublesome asset, replace it with a better asset like life insurance, win, 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 win. This can be really magic for real estate professionals when you have a client that says, I want to get rid of that thing. It's a hassle. Like raw land, commercial buildings that are not in good shape, all kinds of things like this where people say, I need to get rid of that, but there's some tax problem where I'm stuck with it. This is the solution. So a little bit about the CRT. We'll move on to our last consideration, and we're on time here. This is a little bit of a mega topic. I'll just brush over this lightly because I kind of always end on this topic. I teach this class. I teach the estate planning class at Lincoln Law School, and then I sometimes lecture at Santa Clara. I tell the students this topic. New York University has a special degree in tax planning, and this takes a full year with 9 classes to go through this. So we're going to just broad brush how complicated this is, but give you a little bit on it because career professionals, you are going to see this. I have a great friend in Minnesota, a top lawyer out in Minnesota, asked what I practice. I say I practice a lot of this estate, this international estate work. He says we never do that in Minnesota. We don't encounter those clients. I said, well, in Silicon Valley, probably every 4th client is going to have this profile. So let's just dive in just a little bit of basics for us to know. A couple of things. First thing, for U.S. persons, foreign persons who are non-resident aliens, no green card, no visa status here, should not become trustees of U.S. trusts. So when you're thinking of your trust, if your parents are in Singapore or something like that, they're really not a good trustee for your trust. It's going to cause lots of tax problems. You will need a US-based trustee. So thinking on that, foreign persons not good trustees. The other thing, foreign persons are not ideal, foreign persons, non-resident aliens, someone who is not domiciled here, and that's a complicated concept, but someone who's not domiciled here are not ideal owners of real estate in their own name because the estate and gift tax exemption is $60,000. So if they die owning that property, it's $1 million property, we subtract $60,000 and $940 gets the applicable estate tax rate. Terrible result. So what they need to do is arrange structures such as an LLC and an irrevocable trust, LLC under a foreign corporation, LLC under a foreign trust, something like that. So if you have clients that are foreign persons, persons from abroad, and they say, oh, I'd like to diversify my portfolio, I'd like to buy US real estate, you say, fantastic, I have 20 properties to show you, and a lawyer and an accountant to introduce you to, because we don't want to screw this up. Classic thing, I had a person who, a broker who nearly had a problem with this. And we represented the client. The person, I'll tell the story because it's kind of funny. Daughter comes over. I think many people speak Chinese. She is the Fu'er Dai, so the rich second generation, and she gets into Stanford. How I don't know, but she goes and she sees the Stanford dorms, and mom's with her, and she says, "I am not living in the Stanford dorms. No way." And they're driving around Menlo Park. There's this little cute Menlo Park cottage. It has a sign, real estate, and the guy's out there. And he says, Mom, she says, Mom, I want that. I want to live there. It's pretty. Buy that. And Mom is the best real estate client ever, calls the guy, literally calls and says, I want the house. And he says, oh, I'll go do an open house. I'll take you there right now. She says, no, all I need to know is where I wire the money. We drove by it, good enough. And so, of course, really good, client, but they don't think it through. Mom's only been in the US one other time, like 10 years ago, just here on so the tourist visa, just to drop off the daughter. Mom takes title. Daughter gets on the internet, the font of all good legal advice, and decides around Thanksgiving that mom shouldn't be on title, daughter should be on title. So She goes and does a quit claim deed. Mom comes over for Thanksgiving. They go to the San Mateo County recorder to go record the quit claim deed. San Mateo won't take it. As real estate professionals, you probably have seen, you need the P Corps and you need that weird DTT tax affidavit in San Mateo County. If you've ever recorded and you have the D and the P Corps and they say, no, 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 we're not going to take that. Go fill out this other thing. They have another thing in San Mateo County, where if you are not paying the documentary transfer tax and you're doing a gift, i.e. like a quitclaim deed, you have to check the box and say, I have read and understood Title 26, Section 2000 to 2600, and I knowingly, intelligently, and voluntarily accept that gift tax may be owed by the grantor or the grantee, signed under penalty of perjury. Of course, they sign anything, sign it. The clerk says, $35, please. There's your deed. And then the clerk swivels around and throws it into the fax to the IRS. San Mateo County does it all the time. Alameda, Santa Clara, not so much, but it's totally out there. San Mateo, almost all the time. And the IRS basically checks and says, Wang Xiaojun, on July 30th, 2020, what was your immigration status? What was your status? Chinese national. And what was your status in the US? Tourist. Did you intend to permanently reside in the US? No. They say, $3 million, $2 million, minus 60,000, apply 40%. Here's your bill. You owe $700,000 in gift tax. Big, big problem. So anyway, the reason I tell the story is this is a classic potential example of, for real estate professionals, when you deal with the non-US person, say, to find you a great property, you may want to chat with a lawyer and an accountant on this just to make sure that you're safe. Let's go look at houses. Because again, the broker potentially dodged a little bit of a bullet here, because the worst thing I'd hate to see is agent broker say, don't worry about it, you can fix it later, don't worry about it, it's fine, and you have that email, and then the client has a $700,000 bill, and when people get $700,000 bills they don't expect, maybe I'm just a lawyer, but they look for somebody to sue, and they get pretty mad. So classic thing to protect yourselves, say, non-resident aliens, refer to lawyer and accountant, say those are questions for them. My question is finding you a good property. That stuff we give to another professional. And then that way, if they get mad and they say, I don't like it, you say, well, I gave you a list of 2 lawyers and 3 accountants. If you didn't, take care of yourself, that's, I don't know what more I can do. I gave you all of the professionals that you needed. So a tip for that. Just a couple of last things is foreign persons can be beneficiaries of trusts. So if you have your parents in Singapore or Korea and you want to take care of them, you can totally do that. You just have to talk to the lawyer to make sure it's done in a right way, so you don't have the problem number 1 or number 2 that we just saw. The other thing is, which is very, very important, is for foreign persons, they can also be guardians of minor children. This is very common for people who come over, young engineers and things like that, and they say, if something happens to us, I want grandparents in China to be the guardians of the kids. You can do that, but it's a little bit complicated. And generally what I recommend is that you have temporary guardians named in the will, and then the will also names the parents, and then the will also has an explanation for, especially maybe husband's side, if the kids will go to the wife's parents, that explains that husband understands that and accepts that, or the same way the vice, if it's going to the husband's parents, that wife understands and accepts that. Because again, when there are children involved, especially if they are US citizen children, and the guardian may be a foreign person, the court's going to look at that really, really carefully. So you want to make sure you buttoned that up and made in a way that is safe and reasonable. We've got some questions a little bit on the issue of foreign persons. Let's say a foreign person owns a property. How do you unwind that? This will be something that I'll give you more, or feel free to talk to me later and we can discuss more specifically. There are some ways to unwind it. No way is perfect, but there are some ways where either you use an LLC and transfer the LLC interest. Sometimes you'll use a corporation and transfer the corporation. Sometimes you'll do whatever. So there are a few things there. So that is my sort of 6 items there. We're kind of just on time, and I have, skipped it. So that's actually my 6 things. We're at a little over at 54 minutes, but I think that's a lot to think about.
Thank you. Wonderful. Thank you so much, Michael. Just as you promised, thank you so much for giving a great presentation on not just the basics of, what to look out for, but going a little bit on a deeper level and actually giving us some really great examples. So we really appreciate that. I'm going to go ahead and put Michael's information up on the screen shortly. And that way, as our members, go ahead and feel free to contact Michael directly for any specific questions. And that wraps up our speaker event for today. And we'll go ahead and open up for Q&A. We do have a few questions currently. So for those of you who joined a little bit after when we started, just know that the Q&A box for when you want to open up your Q&A box, it's in your menus. You want to click on the 3 dots, and then there should be a Q&A section. So go ahead, open that Q&A box up, and then type in your questions if you have any, and then I can go ahead and read them aloud for Michael to answer.
Yes, and we do have another speaker event next month on tenant evictions and rent moratoriums by very experienced landlord and tenant attorney, David Banacrossi. Feel free to leave in the chat any topics you'd be interested in seeing next time, and we will go out and find the right person to speak. Please be sure to follow CAREA on Facebook for future updates. We will send the link in the chat now.
Right. Okay. So thank you so much, Shen. We do have a few questions for Michael, so let's jump right in. Okay, so Mary's asking, yes, the copy of Michael's PowerPoint as well as the recording will be sent out to everybody likely tomorrow morning. And then let's see, is this going to be replayed or posted online? Yes, it will be posted on YouTube as well as on Facebook. And then slides will be available. Perfect. Let's go to the next one. Okay, so here's a scenario from Stacy. She's asking, a property in San Diego titled under both parents who are foreigners, what is the best way to pass the property to their son who is in the U.S. and a U.S. citizen to avoid most tax?
Okay, well, I'm glad you started out with the most difficult question you could have asked. This one is hard, and I will basically leave the answer as this. There is not a perfect system under the law to do this, but there are potentially good options. First thing we have to ensure is actually that the parents are actually foreign in the sense that they are not domiciled here. So actually, if one is a green card holder or even on a long-term visa like an L1, potentially you could deem that they are domiciled here, at least at the time of the transfer, and they are exempt from the gift tax to the $5 million or $11 million. That's an option. The other thing is that if they truly are foreign persons, they truly are like the person in my example, the gift tax is extremely bizarre in what it considers U.S. property and not U.S. property. U.S. land, U.S. property. U.S. bank account, not U.S. property. U.S. cash, U.S. property. So how weird this is. If I take cash and I put it on the counter, $1 million, and I push it over to Michelle, I am subject to tax. If I go to the bank and tell the bank, can you put Michelle on this account and take my name off? No tax. It doesn't make any sense, but that's the law. So one of the things is that partnership interests and interests like corporate stock and an LLC are considered non-US property. So sometimes using an LLC and transferring the membership interest can avoid the tax. But as we mentioned with LLCs, that comes with a cost. It's a single family residence. It will cause all of those problems. So again, this is something that offline, if you have further questions, it's a great thing to talk about offline because this one's a hard one. I have another question from Monita, if you'd like to read, Michelle. This one's an easy question that I can talk to you about.
From Monique, do you want to just take it on? Maybe you can read it out.
Yeah, let me just have at it. Mm-hmm. Transfer on death deed. So I have this is new. The transfer on death deed is basically this. If I have a piece of real property, I can just do a deed where I say, Michael Lee, if something happens to me, give it to my son, Bobby. And I record that and it would transfer to the next person up automatically. The problem with this is that it's a little bit of a half measure. I think for someone who had a very small estate, who did not have anything sophisticated, it is, it could be okay. You prepare the deed and you record it for $30, and it's just fine. The problem where it doesn't work well is it has that same problem as a will, in the sense it doesn't help you at all for incapacity, because it's only effective transfer on death. So if you're bothering to do the TOD deed, and especially if you have multiple properties, you're really going to be better served by doing the trust, because then you have it all in the box. If I lose capacity, my trustee steps up, takes care of me, manages the properties. I pass away, trustee steps up, moves the properties to the next generation. Also, that property tax issue, if I have 2 or 3 properties, my trustee can apportion intelligently to prevent fractionalized title. Transfer on death deeds, if you have more than 1 children, will always fractionalize title and cause that problem with the brother and sister having to clear title amongst themselves. So that is a problem. So the transfer on death deed, I kind of think of the transfer on death deed as something that I would recommend to somebody who had a not so valuable property out in Eastern California, that the idea of doing the trust was just kind of a little bit, too much work, a little bit too expensive. And the property was maybe $200,000, $300,000 property, something like that. Using it here for a very valuable property, I think you are exposed in issues of incapacity. So it just doesn't, it's not complete planning. The other question that I have is, you charge a consultation fee. If you put CAREA in the email, we don't. So
Thank you.
let everybody know that that say we were with CAREA. This is why we're here, and we're happy to do a 30-minute thing with you and try to see what we can do to help and see if we're a good match. Remember, CAREA in the email, otherwise I won't know where you came from. So let us know that. But we look forward to hearing from you and working with you on things like that. So consultation, and then also now with Zoom, consultation has become very lively. Zoom, Cisco WebEx, we can do it just like we do this, but one-on-one, private.
So Barbara's asking now, do you have a Chinese-speaking staff?
Yes. Alas, my Chinese is terrible. So I can chit chat, but I can't do legal work. My partner, Xiaowei Li, she is a native Mandarin speaker. So she's can do everything that I did, as lively and charming as me, and in Mandarin Chinese. So we can do it. And of course, read and write. If you would wish to do the entire thing in Mandarin Chinese, we can do that. So if you need Cantonese, we can arrange Cantonese, but that will take us a day or two to arrange Cantonese. And Mingnan we can do too, but it takes us a day or two.
Minanji, that's Taiwanese.
Yes, Taiwanese, yes.
Yeah. Thank you so much, Michael. We have actually another question from Kathy, which is, if the sister, like let's say Kathy's sister, not her children, right? So if the sister has the option to buy the house, does this change the tax base?
Yes. So if you create a trust, basically it's a good thing. So if, let's say, the parents are trying to say, maybe my daughter will want an option to buy the house. If you create the option in the trust where you say that the house is subject to the option of one of the siblings to buy, that can help avoid the problem of the reassessment. So that can avoid that problem. So if you have the trust where it grants the daughter the option, and she exercises the option, and she gets a loan and buys out the brother, if that's the way the trust was designed, no property tax reassessment for her. But if it just said 50% daughter, 50% brother, and that's all it said, and they negotiated the buyout on their own, it gets reassessed when she buys him out. So that's not so good. So thinking for long term for families, they should think, does one of the kids want to buy out the other one? Oftentimes, like for me, my kids are, 1 month and 2.5. I don't know whether the baby is going to want to buy out the brother. What you have to do is look at your plan every 3 to 5 years as family life develops, and sometimes make amendments and make sure that the plan has caught up to you. There's another question here. If you have a question, Michelle, or I can take a look at this one.
Yeah, we have actually, I think, 3 more questions, so we're going to cap it here. I just want to be very respectful for everybody's time. I have one more question on my end, and then we can go into the Q&A box. So Kathy's also asking, for foreigners, if they sell the property, they are only subject to the capital gains tax. Is that right?
Oh, say again?
For foreigners, if they sell a property in the US, they are only subject to the capital gains tax. Is that correct?
Yes, but be aware, if any of you've closed one of these transactions, the FERPTA, and having the client freak out and the buyer, and especially the buyer, being very strict on saying, oh, we have to make sure that those tax returns are filed, because otherwise they're going to stick me with these taxes. So just be aware of when you have a non-resident person, they only have to pay the capital gains tax. But especially if they're the seller, first thing, do everything you can to get them the ITIN as soon as possible. Because when the ITIN is because if they don't have a social security card number, if you have a sale that completes and basically you have several $1,000s, sometimes tens to hundreds of thousands of dollars floating around in the imagine this, floating around in the IRS with no number attached to it, God help you trying to figure out how to get that refunded and get that appropriately settled. For those are other transactions. This usually helps talk to the accountant, talk to the lawyer real quick when you see someone say, we got to get the seller, get the ITIN, we got to get the tax queued up, we got to get the scheme ready, because when it closes, it's going to cause this kind of odd withholding of the taxes. And also, if you do it that way, the title officer and escrow officer are going to love you, because you're going to be so ahead of the game that they're going to say, oh, great, everything that used to give me a headache with the title escrow officer, I don't have to worry about, because I already have the ITIN, I already have the client already is prepared for what I'm going to say. They're not going to blame me as the title company, because it's not me, it's the IRS that makes me do this. It makes things a lot better.
Got it. Thank you. Okay, so we have another question here from Michael. If a parent left 2 siblings half and half of the asset and spendthrift on one sibling, can that sibling with the spendthrift transfer half of their inherited property to the other sibling without the property tax going up?
You could do something like this. So the spendthrift clause, and depending on how it's written, some of them are written where they're directed to outside creditors, so that the spendthrift does not necessarily bind me as the beneficiary, but prevents attachment of debts from outside creditors onto the interest. The other version is the one that tries to prevent me as the beneficiary from squandering the money. So there's some provision where the trustee doles out $1,000 a month or something. You can do something to adjust this, but it's a little bit not ideal, because one of the things with the problem with the spendthrift clause or anything like this situation is generally and this may be actually wrong the way the Board of Equalization is taking this position, but they seem to be taking this position. A disclaimer, if let's say the person who's the other sibling disclaims, says, I don't want anything from the estate, with the thought that they're going to let the other sibling have it, the BOE is generally saying that still causes reassessment. I don't think that's necessarily right, but they seem to be saying that. So the disclaimer method is maybe still on board. Maybe you could do that, but you might have to fight with the BOE a little bit. The other thing is with the transfer to the other sibling, because the transfer is basically a disclaimer. The other thing is if there's a spendthrift clause, the issue is it's only if you want to buy one or the other out. If there could be some agreement with both siblings in the spendthrift clause that we say, we're not going, you're just going to stay on title, and I'm going to use the spendthrift clause to prevent you, other brother, from selling the property, and I'll just carefully dole out the rents to you, you may be able to avoid the issue until the property is sold. So there are some strategies on that. So if you have further questions, we can follow up on that. I see another question, looks like it popped up.
Yep, I think there's just actually two last questions. One's from Jay. Will a revocable living trust protect the rental property from being sued in case there is any legal law issue with the tenants?
No, a revocable trust will not help you on this, and an irrevocable trust will not help you on this. I saw a terrible plan the other day. Actually, I was making fun of this with lawyers. There's a bad tenant, and for some reason the lawyer said, let's put the property in an irrevocable trust, which makes zero sense. Because think about the problem. So the problem is coming from the tenant who's in the property. So the only thing that can prevent the tenant problem from going into the other estate or the rest of the estate is that you contain the property in some kind of container, such as an LLC. So you could, to contain properties, place them into an LLC to prevent the tenant problem from flowing out. But all of the things that I mentioned about being careful of the LLC, that's true. And then also remember the obvious. The property is in the container, and that is part of what's in there. So if I have the tenant and the tenant sues and gets a judgment for $50,000, if I have $50,000 of equity, it's exposed to the tenant. So the use of a revocable or irrevocable trust for issues of the tenants in the particular property, that doesn't work. LLCs can sometimes work. That can sometimes work. Sometimes you could create structures like in commercial buildings where you'll have an LLC and the property has a large loan on it, so there's not very much equity, so there's not very much available. You can do things like that, but just putting a property in a revocable trust, irrevocable trust, that doesn't work because the property is what's radioactive. The property is what's causing the risk. So the only thing you can do is try to put it in a container like an LLC, but you have to think through whether or not that is wise.
Thank you, Michael. Okay, so Matthew actually sent over a question to me privately, but this is regarding undeclared foreign assets. Matthew asked that you go ahead and contact Michael directly through an email. I think that would provide you with the best information. So I'm going to end with one last question with Al, which is how do you expect estate planning strategy to change with the potential upcoming California prop? Would it be better to do planning after November?
Is this the one for Al? Are you talking about the thought that we were going to re-implement the estate tax or the state estate tax? Is that the concern? There is I'm going to assume that that's what Al means. If Al wants to pop in with what ballot measure he means, or if he means that's the California prop, or if he means the federal estate tax. But I think the California thing, there was some talk about California re-implementing our state estate tax. Like anybody from Oregon and Washington, they have the federal estate tax, and their state also charges an estate tax. You also, when you pay, the death tax, you also pay your state. California, since '89, we haven't had this. Regarding California, I'm as shocked as you are. This proposition to impose the California estate tax seemed to be, in both the state assembly and the state legislature, super unpopular. California loves taxes, but this one they seem to not like. And this failed in the legislature, both in the assembly, and in the House. So I would really not too concerned about this coming up and being a big problem for present estate planning. The things that I would take a look, and one other aside on this, revocable trust planning, I recommend do this, feel free to do this at any time, because revocable trust planning, you can always adjust. The question is let's say if federal law changes and the federal estate tax changes, or we do get, a California estate tax, is unlikely, but if we get it, what you then start to look at is permanent planning like irrevocable trusts. So I'd say no need to worry now. I'd proceed with ordinary course safe planning. And then if we start to get some unfavorable law, then we react to it. And generally, the effective date for any law is generally January 1st to January 16th of the next year. So let's say it passes in November, then we just are really busy in December fixing it before the law actually passes. So it's pretty common to just do it that way. So I wouldn't be too, I wouldn't feel that there's such uncertainty at the moment.
Thank you, Michael. So here is the contact information for our speaker, Michael Lee, today. Feel free to reach out to Michael directly for any of your specific questions. We will be sending out this entire presentation as well as the recording first thing tomorrow. And Shen, why don't we close up?
Yeah, okay, let's close with a special thank you to Michael Lee again for sharing some great info today. And thank you everyone for your participation. Have a great rest of your week, everyone, and stay safe.
All right, take care all.
Thanks. Bye, everybody.
See you next time.